that this was right. And they were here at the right place, celebrating this party and celebrating this politics.
I mean, I as a child grew up in Germany, and I saw what happened sometimes, when they had these mass rallies, and when I saw Hitler's speeches.
10,000 German lawyers and judges took an oath of personal loyalty to the Führer.
In Nazi arguments, the law is the will of the Führer.
Because he brings the hope, the glory, the pride.
And then it all went horribly wrong.
In 1933, less than a month after being elected Chancellor, Adolf Hitler used the pretext of a fire in the Reichstag building to suspend constitutional law and place unlimited judicial authority in the hands of the government.
That was a cataclysmic event. I mean, think in terms of our capital burning down. The Reichstag was their Congress, and the Reichstag couldn't meet. When the Reichstag is not in session, the Chancellor has emergency powers. So here you have Adolf Hitler given these enormous emergency powers to do almost anything that would be contrary to a democratic society.
The German legal system in 1933 was a very sophisticated legal system. This was not primitive law. It was really seen, German legal science was really seen as the height of what law was supposed to be about.
After the burning of the Reichstag, which was more than a symbolic act in destroying the parliament, 10,000 lawyers took an oath. Not surprising, I've taken an oath as a lawyer to defend the Constitution of the United States. But 10,000 German lawyers and judges took an oath of personal loyalty to the Führer, which is the antithesis of what we think of as the rule of law.
So the Nazis coming to power realized that the law was a very powerful instrument in order to get the German public to follow and to acquiesce in those early steps.
The principal procedure governing German law during the Third Reich was something called the Führerprinzip. And the idea was that Hitler had absolute discretion to make any ruling whatsoever in the interests of the state, and that there were lesser or subordinate Führers who also followed the Führerprinzip and themselves had wide discretion, limited only by what the Führer above them had told them to do.
Over the next 12 years, the Nazi Party continued its subversion of constitutional safeguards until Germany's courts amounted to nothing more than tools for the implementation of National Socialism. Early in their subversion of law, Nazi officials established special courts to deal with anyone the party deemed an enemy of the Reich. In these courts, there was no pretrial investigation. Judges determined arbitrarily what evidence to consider, and there was no right of appeal.
Now, this is the time when the judiciary could have and should have stood up and said, wait a moment, we have rules and laws here. This is our nation that is being corrupted. And the Chancellor said, this is only temporary because of the terror that's been visited upon Germany.
Once he succeeded in concentrating legal authority into his own hands, Hitler then had the tools for eliminating all those he deemed to be enemies of the Reich. Primary among these were Jews and other minorities. Before the Nazi era, Jewish lawyers constituted a large percentage of Germany's legal community. With Hitler's rise to power, Jews were no longer allowed to practice law. Eventually, most lost their lives as well. One who survived, Max Friedlander, was a distinguished legal ethicist. After his escape from Germany, He wrote memoirs that offer a vivid portrait of life before, during, and after the Nazi era.
On January 30th, 1933, I was in Berlin for a meeting of the Board of Directors of the German Bar Association, when a telephone call informed us that Adolf Hitler had become Chancellor. But it was only later, after the Nazis had swept aside all legal barriers to their reign of terror, that we would come to understand the full implications of this event.
Und außerhalb Europas gelingen sollte, die Völker noch einmal in einen Weltkrieg zu stürzen, dann wird das Ergebnis nicht die Bolschewisierung der Erde und damit der Sieg des Judentums sein, sondern die Vernichtung der jüdischen Rasse in Europa.
The German Bar Association soon met its final fate. All votes on resolutions were held under the supervision of the SA, and I would not have advised anyone to cast a dissenting vote. In a similar manner, the regional bar associations and the Bavarian Lawyers Association disappeared. On April 7, 1933, the German government enacted a law forbidding attorneys of non-Aryan descent from representing Aryan clients. If anyone dared do so, their names were published in the press, their businesses were boycotted, and soon it even became grounds for divorce.
When the Nazis first came to power, they ended up promulgating a number of laws that incrementally deprived Jews and other persecuted minorities of civil rights. These incremental steps that we're talking about that results in the final solution were all legal steps. And you can trace this, you can trace the Holocaust as a legal event.
Genocide, the extermination of whole categories of human beings, was a foremost instrument of the Nazi doctrine. We shall show that these deeds of men in uniform were the methodical execution of long-range plans to destroy ethnic, national, political, and religious groups which stood condemned in the Nazi mind.
If you begin with the assumption that you are a member of a superior race and that others who have a different color or a different religion or a different ideology are inferior, then it begins to follow that the superior one should dominate the inferior one or eventually eliminate him as well.
Doctrines of so-called criminal types were implemented that allowed Hitler's courts the further liberty of condemning enemies of the state, not based on what they had done, but on the sole basis of who they were.
The enemy, which we regard as enemy, has to be pursued, not because he has done something wrong in our eyes, in the eyes of the state leadership, but because he is different. It was a principle of the National Socialist Constitution that the race is a very, very important point, and that everybody has to be treated according to his race. This was official state doctrine. You couldn't act openly against the state doctrine.
Übergeht alles Undeutsche dem Feuer gegen Klassenkampf.
Perhaps future generations will read about the books that were burned, forbidden, boycotted, often not even for their content, but because of their author's race. I was leafing through a recent Nazi commentary on laws governing attorneys when I found sentences lifted verbatim from one of my own books. Roland Freisler, Undersecretary in the Prussian Ministry of Justice, wrote a review. He said, "For decades, the German bar had to accept the shameful fact that the law governing its conduct was commented on by Jews. Now, at last, a German commentary has appeared." Here was a truly new way of fighting Jewish intellectual property. You just brand it as inferior, then copy it, and now praise it as an Aryan creation.
In 1934, the People's Court was established to try those accused of political offenses. Eventually, the court came under the presidency of Roland Freisler, a Nazi of such extreme sentiments that he shocked even his fellow Nazi judges.
Wo sind Sie hingegangen? Chemische Erzeugung, haben keine Ahnung von Chemie. Werden Sie lieber eine Knarre in die Hand genommen, wäre ich auf dumme Gedanken gekommen. Aber natürlich, Sie haben ja bestätigt, dass Sie KVer sind. Also, und werden Sie hier nicht unverschämt. Mit Ihnen werden wir fertig.
Freisler was one of an echelon of senior German jurists who paved the way for the betrayal of the rule of law in the 1930s. Carl Schmitt, Hitler's legal theorist, a wealthy and ambitious conservative who described the Führer as Germany's guardian of justice. Erwin Bumke, the man who drafted Hitler's emergency laws. These and other senior officials of Hitler's courts empowered police to disband organizations, seize assets, make arrests, and determine on their own initiative what constituted a threat to the state.
Dass gewillt und geeignet ist, in Treue dem deutschen Volk und Reich zu dienen. Eheschließungen zwischen Juden und Staatsangehörigen deutschen oder artverwandten Blutes sind verboten.
The Nuremberg laws reflected Nazi preoccupation with racial purity, an idea concocted from vague elements of religion, citizenship, and heredity. Since the laws defined Jews as racially impure, marriage between Jews and non-Jews would defile the race and was now prohibited. Resourceful judges found other applications for the Nuremberg laws, by arguing, for example, that because Jews were no longer considered full human beings, they did not qualify for legal rights. In effect, Jews and other minorities underwent a civil death long before millions met their physical death in the camps.
I could no longer afford to live in the beautiful house that had been my family's home for 28 years. Our dear friends, the Herzfelders, had an apartment available on the second floor of their house. I arranged to move in with them and began the painful process of selling my home. The Herzfelders and I had been listening to the radio before retiring. Around 4 a.m. on November 10th, 1938, I was awakened by loud voices. 5 SA men yelled, "Police, open up!" and then declared that Herzfelder and I were under arrest. When we arrived at our local police station, something surprising happened. The officer on duty was someone I had known for a long time. He told the SA men, "There's been a mistake." Then to us he said, "You're free to go." We walked home. We saw the Gestapo busying themselves in other homes. That same evening, thousands of Jewish men, in particular, nearly all the lawyers and physicians and former judges and prosecutors across Germany, were arrested and dragged off to concentration camps.